All right, good afternoon, folks. I'm Judge Corey Friedman. This is first appearance. The purpose of today's hearing is for you to be informed of the charges against you, for the court to determine if there's probable cause, determine bond, if any, and determine release conditions, if any. Please note, I've reviewed the arresting affidavits, the charging documents, and any other materials provided to me. After today, your case is going to be assigned to a specific division judge, and moving forward, any pretrial motions and any trial will be heard before your division judge. Any matters not addressed here today by your division judge, and any matters that are addressed here today can be readdressed by your division judge. If for some reason you're not eligible for bond at this time, you'll see your division judge for relief. Generally, I will not change. Out-of-county holds, out-of-state holds, immigration holds based on violation of probation, community control, or parole. However, I do look at each case independently. It's important that each of you understand today is not your trial date. Because of that, we're not going to be talking about the facts of your case. We're not going to be talking about the facts leading up to your arrest or any potential defenses. I do understand that sometimes defendants want to speak on the record, and that's generally okay. However, before you do, I strongly encourage that you talk to your attorney first. And if you do speak on the record, you limit your comments to considerations relating to bond and or release conditions. Additionally, it's important that the court let you know you have the right to remain silent, and anything you say can be used against you at a later date. Additionally, these proceedings are being recorded. If you're represented by the public defender's office, attorneys from the public defender's office are present in my courtroom and at some of your locations. If they are not physically present at the location where you are jailed, they should be available to you by phone. For those of you who are represented by private counsel, your attorneys may be present in the Zoom room or in my courtroom. Additionally, in the courtroom, we have representatives from the state's attorney's office, confinement status, pretrial supervision, and the clerk of courts. These individuals are here to facilitate the session and to provide additional information to the court as may be needed. Please note, I may take cases out of turn for certain reasons, including but not limited to the need for interpreters, security reasons, medical reasons, and because some attorneys need to be in other courtrooms. If I do take a case or cases out of turn, please don't think I'm doing it out of preference or for any other reason. Folks in the gallery who wish to address the court, please make sure you check in with the deputy and let him know which matter you're here for. If you're only here to observe, there's no need for you to check in. For those of you on Zoom, please be advised I control the mute button and will unmute you when it's your turn to address the court. If you're an attorney on Zoom, please turn on your video and use the raise the hand icon so I can unmute you and check you in for your case if I haven't done so already. All others on Zoom, if you wish to address the court when a particular case is called, please turn on your video and use the raise the hand icon. Until your case is called, however, please keep your video off. If it is not off, I will turn it off. If you're simply observing, please likewise keep your video off. Folks, I know I've mentioned this before, but it's worth repeating. Everything is being recorded. All right. With that said, let's start on page 8 with Robert Brown. We have counsel on Zoom.
Good morning, Your Honor.
Mr. Brown is a refusal.
Oh, okay. All right. So he's a refusal, but that's fine. State, it sounds like you and counsel have an agreement.
Yes, Your Honor, we agreed to a $2 bond on one, and he'll be seeing his judge next week on the BOPs.
All right. So the court does find probable cause. And counsel, is that correct? $2,500 on one?
Yes, Your Honor.
All right. So bond will be $2,500 on one. He has no bond holds on 2 and 3. And then the other matter is a citation not before this court. Good luck to you, Ms. Rastatter.
Thank you so much. I appreciate it.
All right, let's start with Carolina Zavala de Juarez.
North Brown requires our Spanish interpreter.
And he just walked in.
Perfect timing.
All right, sir, can you please raise your right hand? Swear or affirm to translate from English to Spanish, Spanish to English to the best of your ability? Thank you. All right, Miss Zavala de Juarez, can you please confirm that you can hear and understand the Spanish interpreter who was just sworn in?
Señora Zavala de Juárez, ¿puede por favor confirmar que escucha y le puede entenderle al intérprete que acaba de ser juramentado?
Sí.
Yes. Yes.
Ma'am, you're charged with one count touch or strike battery. The court does find probable cause.
Señora, usted está acusado de un cargo de lesiones mediante toque o golpe. Considero que existen indicios probables de delito.
State your recommendation.
No.
Recomendaciones
No.
fiscalía.
Your Honor, recommending a $2,500 bond, no victim contact and no return.
Su señoría, estamos recomendando una fianza de $2,500 que se le prohíba tener contacto con la víctima y también regresar al sitio de los hechos.
Your Honor, the increase, the bond recommendation is based
Recording in progress.
De que presuntamente golpeó varias veces a la víctima.
while her co-arrestee was choking her.
Mientras la coacusada o coacusado que fue arrestado junto con ella estaba estrangulando a la víctima.
No, no, ella está mintiendo. Ella está mintiendo.
Ma'am,
Es
hold on.
no.
Ma'am, hold on.
Señora,
Defense?
espere.
Your Honor, I haven't been able to speak with Ms. Zavala de Juarez because of my inability to speak Spanish well enough.
De parte del abogado defensor, dice su señoría, no he podido hablar con la señora Juárez debido a la barrera de idioma.
But if I could just remind her, I recommend not saying anything at this time. You'll have a chance to try to fight these charges at a later date, but I don't want you to say anything right now while you're being recorded. I'm trying to protect you.
Señora Zavala, le recomiendo que no diga nada en este momento. En el futuro, más adelante, usted podrá argumentar a su propio favor, decir lo que desee decir, pero en este momento está siendo grabada. Así que, por favor, estamos tratando de protegerla. No diga nada.
The goal for today is to get you out of jail, and the state has recommended a bond of $2,500.
El objetivo hoy es sacarla de la cárcel. La fiscalía ha recomendado una fianza de $2,500.
If you get in touch with a bail bondsman, a lot of them will take 10%, which is $250.
Si usted logra ponerse en contacto con un fiancista, muchos de ellos aceptan el pago del 10% de la fianza, lo cual significa que solo tendría que pagar $250.
Do you think you will be able to afford to bond out of jail?
¿Usted cree que posiblemente podría pagar esa fianza para salir de la cárcel?
Sí.
Yes.
No objection, Your Honor.
No hay objeciones, su señoría.
Your bond will be $2,500. I'm ordering no victim contact and no return. Good luck to you.
Bien, su fianza queda fijada en $2,500. Se le ordena no tener contacto con la presunta víctima y se le prohíbe regresar al sitio de los hechos. Buena suerte.
Yeah.
Thank you.
All right. Anybody at the main jail require the use of the Spanish interpreter?
Yes, Judge, two individual. First one would be on page 5 of the court's docket. Mr. Ricardo Bracho Ferrer. Mr. Bracho Ferrer.
All right. Yes.
Do you see the immigration hold on your paperwork?
Yes.
Okay.
Yep.
Thank you.
All right, sir. Can you please confirm that you can hear the Spanish interpreter who was previously sworn in?
Señor, ¿puede por favor confirmar que escucha al intérprete español que ya fue juramentado? Yes.
Sir, you're charged with one count petty theft, second degree, first offense.
Señor, usted está acusado de un cargo de hurto menor de segundo grado en calidad de primer delito.
One count resisting an officer obstruction without violence.
Un cargo de resistirse a un oficial o obstruir a la policía sin violencia.
And you have a no bond immigration hold.
Y tiene una orden de detención de migración para la cual no hay fianza aplicable.
The court does find probable cause.
Considero que existen indicios probables de delito.
State.
Fiscalía.
Your Honor, recommending a $150 bond on 1, $500 on 2, with no return.
Su señoría, vamos a recomendar una fianza de $150 para el primer delito, $500 para el segundo y que se le prohíba regresar al sitio de los hechos.
No objection.
No hay objeción.
Bond will be $150 on 1, $500 on 2.
La fianza queda fijada en $150 para el primer delito, $500 para el segundo.
No bond hold on 3 and ordering no return. Good luck, sir.
Hay orden de detención sin posibilidad de fianza para el tercero y se le prohíbe regresar al sitio de los hechos. Buena suerte, señor.
Hey, Judge, the last gentleman that's going to require Spanish interpreter is on page 10 of the court's docket, Mr. Darwin Miranda. Mr. Miranda?
All right, good afternoon, sir. Can you please confirm that you can hear and understand the Spanish interpreter?
Buenas tardes, señor. ¿Puede por favor confirmar que escucha y puede entenderle al intérprete?
Sí, sí.
Yes.
Sir, you're charged with one count battery by strangulation. You also have an out-of-county hold for which there is no bond.
Señor, usted está acusado de un cargo de estrangulamiento o lesiones por estrangulamiento y tiene otra orden de captura desde fuera del condado para la cual no hay posibilidad de fianza.
The court does find probable cause.
Considero que existen indicios probables de delito.
State.
Fiscalía.
Recommending a $10,000 bond, no victim contact and no return.
Estamos recomendando una fianza de $10,000 que no tenga contacto con la víctima y que se le prohíba regresar al sitio de los hechos.
Defense.
Judge, we were going to be asked for the court to consider setting a $5,000 bond for Mr. Miranda.
Señor juez, estamos solicitando que contemple la posibilidad de imponer una fianza de $5,000 para el señor Miranda.
He's employed, he does tile for a living.
Él tiene empleo, él pone tejas y así es como se gana la vida.
My understanding is his sister's going to help post his monetary bond.
Tengo entendido que su hermana es la que va a ayudar a pagar su fianza.
He really doesn't know how much she can afford, but he said it's not much.
Él no sabe cuánto puede pagar ella, pero dice que no es mucho.
That is why we're requesting a $5,000 bond on his behalf.
Y por ese motivo estamos solicitando una fianza de $5,000.
All right, bond will be $7,500 on one, no victim contact, no return, and no bond on two.
Bien, la fianza queda fijada en $7,500, pero el primer delito se le prohíbe tener contacto con la víctima y se le prohíbe regresar al sitio de los hechos para el segundo delito.
Judge, nobody else in Maine requires a Spanish interpreter.
No one at the Northern Jail.
All right, thank you. You can be excused, sir.
Your Honor, if we could possibly call a case this morning, I believe there's another assistant state attorney that's present on this case, and I believe at least one other attorney that's appearing on behalf of a victim.
Which case?
That'd be Louis being Cooley from this morning, Your Honor.
Got it here. All right, so it looks like we've got Miss Alcade.
It's
All right.
Alcalde. Good morning.
sorry.
Good afternoon, Your Honor.
Sorry about that, ma'am.
It's okay. I actually had a judge in Broward call me Miss Al-Qaeda in front of a jury once. He's a great judge. I don't want to mention it, but it's just my name is commonly mispronounced.
Sorry about that. All right,
It's okay.
and then we have Mr. Klinger.
Yes, sir.
All right, and then we have Mr. Bianculli from this morning. I imagine you're going to want to waive reading.
Yes, Judge.
All right, so the court does find probable cause. Let me first hear from state who.
Your Honor, Mr. Klinger at this time, he's going to be taking the lead as far as.
All right, Mr. Klinger, what say you as far as recommendations?
The recommendations there are two VOPs, possible VOPs on 94806. We asked for no bond hold on those two. On for the 94806 charges, in that he was on probation for two felony cases, one of which was sexual battery, and the other was initially sexual battery, then changed to video voyeurism when he pled. No sooner was he out than he committed all these failure to register charges that have now constitute his new case violation. So we would ask that between the new case violation and two VOPs, that he have a no bond hold. If the court so desires to give him bond on the 6 counts on the new case, the state's recommendation would be $25,000 per count, since he has considerable financial wealth. And we would also ask that it would be a tier 1 GPS put on his.
All right, so just so I'm clear, there are 6 charges, and then you're asking for 25,000 each.
On the 6 on the new case charge. Yes, sir.
Correct. All right. That's all I've got in front of me are the 6 in front of me, and then, yeah, that's all I have in front of
Your
me.
Honor, you have 7 and 8 in front of you?
No.
All right, Your Honor, see, that's the reason this, if I may, the reason this case was reset from this morning is the jail had charged him with 2 counts of violation of probation under statute, Florida statute 94806.
Sure, yeah, and I heard,
Yes,
the gentleman speaking about that, but I don't have 7 and 8.
well, Your Honor, if we could, if Your Honor would be inclined to write it in on the findings then for 7 and 8.
Hold on one second. We've got, no, so, all right. So what happened was the paperwork from this morning does not have 7 and 8.
No.
And then it's on the afternoon because we reset it and it's got 7 and 8.
Oh, great.
So I'm just gonna attach this. So 7 and 8, he's asking for no bond holds, and then 1 through 6, 25,000 each. Is that right?
Yeah, sure. With also, if I may,
With the GPS one.
With the GPS level.
All right, let me hear from the other counsel on the line.
Good afternoon again, Your Honor. I represent the victim on one of the original cases. I did put in a notice of appearance on that case. And I
Sure.
can tell the court, we agree with the prosecutor's office, obviously on the VOPs that we'd like a no bond hold. And I think that if Your Honor is inclined to grant a bond, I think the main thing that we would also request is a GPS monitoring because she's, obviously concerned.
Okay, all right. Let me then hear from the defense.
Judge, I did speak to Mr. Bianculli earlier today. I did advise him that Mr. Kirk Cohen was not going to be appearing on his behalf today. I did advise him in reference to count 7A. He's being held no bond on 948 hold in which he's being held no bond. I do see here he's scheduled to see his assigned judge on April 1st at 8:30 in the morning. So obviously he's not going anywhere. He's going to be held no bond on those 2 counts. He's going to try and seek some sort of relief in front of his assigned judge. Judge, if he manages to get some sort of relief, Judge, he is requesting a total of $50,000 bond in reference to counts 1 through 6 at this time.
All right.
Your Honor, if I may, Mr. Klinger, if you don't mind, just so the court's aware, and Mr. Klinger made reference to this very briefly, Mr. Bianculli has substantial financial resources, and that is part of the consideration the state put into making these requests. Frankly, what $150,000 bond to him is not the same as it would be to most people, Your Honor. Additionally, Your Honor, just to advise the court, regarding the level 1 request, the court should be aware of just a little background information. And Ms. Salcati, Mr. Klinger, correct me if I'm wrong. These cases, he was on probation. During the pendency of those cases, the entire time, he was on a level 1 GPS monitor. So the state does believe, should he be eligible for release at some point on these new charges, he would certainly pose the same risk, danger to the community that he posed previously.
All right, okay. At this time on counts 1 through 6, bond will be $25,000. If he does bond out, he'll be on a pretrial GPS level 1. As for 7 and 8, I am going to hold no bond at this time. Anything further from counsel?
No, thank you very much, Your Honor.
All right.
No, thank you, Judge.
Requesting a medical screening order.
Granted. Glad we were able to figure out that issue with the paperwork, which actually fell on me because I just had duplicate of it. All right, so we got that, and then let me see. All right, counsel, let me see if I can hear you now.
Aaron Aguirre is finally available, sir, if you can hear me.
Okay, I can hear you. Which matter are you here on, sir?
Carlos Aguirre.
Let's see.
And sir, I'm assuming his last name is spelled the same as yours?
Yes.
I don't see it.
Fernanda, could you check? I'm not showing anyone by that name that's in custody, frankly, or at least no one that was arrested recently.
Oh, I see it on the It's on page 3.
Is-
It's a ROR, motion for ROR. it looks
Oh,
like.
okay, sorry.
All right, so, counsel, I'll mark you as here. Am I correct? You're counsel for, Mr. Carlos Aguirre?
No, sir, I am his father.
Oh, okay, you're his father. My apologies. You were dressed so nicely, I just assumed you were an attorney.
Your Honor, if you want, I mean,
You want to handle it?
it's a motion for, it's just a 30-day motion, so it's.
He's at North Broward, Judge,
All right,
MPD.
so let's go to North Broward real quick. All right, hold on one second. All right, we have, Mr. Aguirre, is that correct? All right,
Yes, sir, that's correct.
All right, Mr. Aguirre, we're here for a motion for release. We're here to find out if the state has filed their formal charges.
Your Honor, information has been filed.
All right, so, Carlos Aguirre, and, Dad, did you want to say anything on the record?
No, sir, I'm just observing, sir.
Okay, all right. So, Carlos Aguirre, the state has filed their formal charges. That means your motion for release is being denied at this time. You'll proceed to your division judge for further relief. And good luck to you, sir. All right, good luck, folks. All right. With that, let's go to page 2. We have Cindy Guantz.
Ms. Swan, come on up. She's approaching Judge Jermaine.
All right, good afternoon, ma'am. You're charged with 1 count grand theft auto. The court does find probable cause. State?
Your Honor, the state is recommending $1,000 bond.
No objection.
Bond will be $1,000. Good luck to you, ma'am. And then we have Emily Pabutzel.
Judge, she bonded.
Yeah.
Bonded. All right, then we've got Andrew Laney's.
Judge, pursuant to my conversation, waiving his appearance.
The court does find probable cause. It's an out-of-state no bond hold, which will remain in place. Todd Williams.
Mr. Todd Williams, come on up, please. Todd? Approaching, Judge.
All right, Mr. Williams, good afternoon, sir. You're charged with 1 count touch or strike battery. The court does find probable cause. State?
Your Honor, the state is recommending a $5,000 bond, no victim contact, no contact with minors. This is based on the specific allegations in the report. Additionally, noting Mr. Williams lacks ties to South Florida and Florida in general. He also has a pending felony out of the state of North Carolina from February 20th of this year, failure to return a hired motor vehicle valued over $4,000.
All right. This is the
Judge,
airplane.
that is correct. He's not from here. He was on a layover. He's going to Atlanta. Now, he does have, I believe, an aunt that he's going to be reaching out to post his monetary bond. Considering at this time this is a misdemeanor, we're going to be asking the court to consider $1,000 bond.
All right, bond will be $5,000. I'm ordering no victim contact, no contact with minors. Good luck to you, sir. Daniel George.
Judge, he bonded.
Daniel Rodriguez.
Approaching Judge Maine.
All right, Mr. Rodriguez, good afternoon. You're charged with 1 count of trespass. The court does find probable cause. State?
Recommending a $500 bond and no return. Mr. Rodriguez is currently out on a $250 total bond for a pending trespass at a CAO bakery and criminal mischief. That's damage he did to a police vehicle. He also has a prior history as well.
All right, defense.
Judge, he did tell me as far as those misdemeanors that he's currently out on. He was hoping that the state had a plea offer. I believe this was at a laundromat, Judge. Considering there's no plea offer at this time, Judge, he is homeless. He does side jobs for a living, but at this time, he's asking if the court then would consider releasing him ROR.
Bond will be $250 with an order of no return. Good luck, Mr. Rodriguez. Alan Lando.
So Lando is approaching, Judge.
All right, Mr. Lando, good afternoon, sir. You're charged with 1 count resisting an officer obstruction without violence. The court does find probable cause. State.
Your Honor, recommending an ROR.
All right, Mr. Lando, the court will ROR you. If there's nothing else holding you, you'll be released today. However, please do check with the public defender's office. Please do check with the clerk of courts to see if there's any future court events that you need to be present at. Good luck to you, sir. Page 6, William Smith.
He's approaching Judge May.
Mr. Smith, good afternoon. You're charged with 1 count loitering or prowling. The court does find probable cause. State.
Your Honor, the state is recommending a bond of $2,500. Should Mr. Smith post bond, pretrial release with a GPS monitor of level 2, no victim contact, no return. Your Honor, the state would also request that the court impose a curfew based on any information that is provided to the court regarding his information. Your Honor, the court should be aware Mr. Smith was arrested February 23rd of this year for burglary of a conveyance, petty theft, possession of burglary tools. He posted a total bond of $4,000 in that case. He's also out on a pending grand theft auto from last year. And he has a prior 2022 burglary of a conveyance, grand theft firearm, resisting without violence. He violated probation in that case and was sentenced to a year and a day state prison.
Judge, I spoke with Mr. Smith, unfortunately, but no one, and he doesn't have the ability himself to post any sort of monetary bond. Now, this is a second-degree misdemeanor, Judge. He's asking for an ROR. At this time, he is not working, Judge. He's 20 years old, been here his whole entire life. Judge, he did advise me as far as that burglary, the petty theft, burglary tools. It was his understanding that was dropped. Judge, he is once again, he's asking for an ROR. We're requesting a photo order on his behalf.
Your Honor, I can advise the court and Mr. Smith, he was misinformed then.
All right. If I do set a curfew, what sort of curfew, Mr. Romero?
Judge, he said he's looking for work. He hasn't been successful, but he's looking for a type of job for 9 to 5.
At a studio right now.
Oh, 1 second, sir.
3.
Judge, he is working a part-time job. He says he works at a studio, but it's part-time only Monday, Tuesday, Wednesday, 3 days a week from 8 a.m. to 3 p.m. in which they pay him $100 a week. That is his job, but unfortunately it doesn't pay enough. That's why I think he told me that he's currently looking for something that's full-time hours from like a 9 to 5 type of job.
All right. All right, at least as of right now, then his curfew will be from 4 p.m. to 7 a.m. That means he needs to remain indoors 4 p.m. to 7 a.m. Bond will be $2,000. He'll also be on a pretrial GPS level 2. And I am granting the request for a photo order.
And Your Honor, I take back the no victim contact, but I would ask for no return to the incident location.
All right, so I don't think I put no victim contact, but I'll put no return. All right. Jonathan Turner, page 9.
Judge, I've been advised he is a refusal.
Court does find probable cause. State.
Recommending 500 each on 1 and 2, 15,000 on 7, no victim contact, no return.
It'll be 500 on 1 and 2, no bond holds on 3, 4, 5, and 6, 8, and 9, 15,000 on 7, no victim contact, no return. Page 10, Mr. Hightower.
Judge, I've been advised he is a refusal.
Court does find probable cause. State.
Recommending a $10,000 bond on one, 1,000 on two, no victim contact, no return.
Bond will be 10,000 on one, 1,000 on two, no victim contact, no return. Alexander Perez.
Judge, I've been advised he is a refusal.
Nothing from the state, Judge.
All right. Court does find probable cause. It'll be 200 on one, no bond holds on two and three. Mr. Lyon.
Mr. Lyon is approaching, Judge. He's here, me. Come on up, sir. Be careful.
All right, Mr. Lyon, good afternoon, sir. You're charged with one count aggravated battery on a person 65 years of age or older, and one count aggravated assault on a person 65 years of age or older. The court does find probable cause. State.
Your Honor, even though Mr. Lyon has been charged and the state has filed a first-degree felony on a dangerous crime, the state at this time does not intend to seek pretrial detention. Your Honor, the state is recommending a $5,000 bond on count one, a $2,500 bond on count two, no victim contact, no firearms, weapons, or ammunition.
Judge, normally that would be a very reasonable bond, but unfortunately, speaking of Mr. Lyon, that's simply financially out of his reach. He is 73 years old. He did advise me he gets Social Security, he gets about 1,000 in social, he gets VA benefits, at least told me 1,100. Now he lives in Oakland Park, been living at the same place for about 6 months. Judge, he tried to get into the facts. I told him today's unfortunately not the day to fight it. He'll have his day in court. He very much wants to have his day in court. I know you mentioned, I believe, the other two individuals that are in reference to this case. He also went to law enforcement on them. He was deterred by law enforcement. They're going to go ahead and get arrested. I don't know the status of that, Judge, but I spoke to Mr. Lyon. I know he has numerous medical issues. He advised me maybe he may be able to reach out to someone to help post his bond, but at the very most they can do is a total of a $3,000 bond. So I'm requesting a $3,000 bond and a medical screening order on Mr. Lyon's behalf.
State, any history?
I do not see any, Your Honor.
Bond on count one will be $3,000. Bond on count two will be $1,000. I'm ordering no victim contact, no firearms, weapons, or ammunition. I am granting the request for the medical screening. Good luck to you, Mr. Lyon. LaShawn Florence.
Judge, I've been advised he is a refusal.
Court does find probable cause. State.
One moment, Your Honor. This is on Lawrence, Your Honor?
Yes.
Your Honor, recommending a $500 bond on one, 7,500 on two, 500 on three, and no driving until further order of the court.
It'll be 500 on one, 7,500 on two, 500 on three, and no driving.
Judge, even though he was refused, I did look at his booking photo. I'm going to be requesting a photo order.
Okay. Antonio Amos.
Judge, pursuant to my conversation, I'm waiving his appearance.
Court does find probable cause. State.
Nothing can state, Your Honor.
All right, it's a felony capias for which there's a no bond. So that will remain in place. All right. Page 12, we have Nicholas Foster.
Judge, pursuant to my conversation, I'm waiving his appearance.
Court does find probable cause. These are all no bond holds. Am I correct, State?
That is correct, Judge.
All right, so all the no bond holds 1 through 3 will remain in place. Page 12, we have Mr. Brown.
Mr. Brown, come on up, please. He's approaching, Judge.
Mr. Brown, good afternoon, sir. You're charged with one count aggravated battery on a person 65 years of age or older. The court does find probable cause. State.
Your Honor, the state is recommending a $7,500 bond, no victim contact, no firearms, weapons, or ammunition. Once again, Though he is charged with a first-degree felony and a dangerous crime, the state does not intend at this point in time to seek pretrial detention and a no bond hold. However, based on the level of violence that's alleged, and I would also note Mr. Brown's history, 2013 burglary, dwelling, and battery, those are separate counts. 2013 stalking, assault, and harassing phone calls. He's got a much more dated possession of cocaine with intent and a much more dated burglary dwelling. It's really more the stalking and the burglary. That would be the basis for the state's recommendation.
All right, defense.
Judge, I spoke to Mr. Brown. He's 51 years old, been here his whole life. He did advise me as part of contact with the criminal justice system, what the state advised over 10 years ago. Now, Judge, he is works in demolition, been doing that for about 5 years. He's going to try and reach out to a friend or a family member who puts his bond. He is requesting a $3,000 bond. I'm requesting a medical and a mental health screening order on his behalf.
Bond will be $6,000. I'm ordering no victim contact, no firearms, weapons, or ammunition. I'm granting the medical and mental health screening. Good luck, sir. Page 13, Armando Osis.
Judge, pursuant to my conversation, waiving his appearance of court, requesting a medical and a mental health screening order.
Court does find probable cause. State anything?
No, Judge.
All right, so it'll be no bond holds on 1 through 7, 1,000 on 8, 1,000 on 9. And then 10 says no bond hold, but there's a bond of 1,000 next to it. Can I get some clarity on that?
My guess is
It is $1,000.
yeah, I was gonna say the no bond is part of the error.
So I'm gonna put BD. And it'll be 1,000 on 10. The medical and mental health screenings are granted. All right. And then we've got 2 others from this morning. We've got,
Yes, Judge, I believe the first one was on page 13, Mr. Moses Ward.
yep, I've got the paperwork right here.
Moses, come on up. He's approaching, Judge.
All right, Mr. Ward, you're charged with 1 count aggravated battery where the offender knew or should have known the victim was pregnant. 1 count domestic battery by strangulation. The court does find probable cause. State?
Your Honor, the state is recommending bonds on each count of $75,000. No victim contact. Your Honor, just so the court is aware, as you can see in the paperwork, Mr. Ward was brought here from Palm Beach County. Mr. Ward is awaiting sentencing out of Palm Beach County on charges, I believe, of false imprisonment, kidnapping, and sexual battery charges involving the same alleged victim, Your Honor. So that is the basis for those requests. Additionally, just so the court is aware, Your Honor, as far as prior arrest in Broward, Your Honor, he was arrested 2023 in Broward, kidnapping, 3 counts of sexual battery involving the same alleged victim. We decided to find charges that in Palm Beach County that's involved in the Palm Beach matter. He also had an arrest in 2021 for violating a domestic violence injunction. And those charges, that charge was dropped. Your Honor, frankly, and I understand Mr. Ward, maybe described surprised by my recommendation. Frankly, there's no prejudice to him with the state's request, only if for some reason he is no longer held on his Palm Beach County case. I believe he's going to be receiving, from what I've been advised by the prosecutor in this case, that he'll be receiving a state sentence case. There really is no prejudice. I just think it's an appropriate bond amount considering the allegations out of Palm Beach County and the allegations in this case.
All right, let me hear from the defense.
Judge, obviously, Mr. Ward is denying these allegations. He did tell me he has a Palm Beach hold. He's scheduled for sentencing on that. Now, Judge, my understanding in speaking to Mr. Ward, He's been residing here his whole entire life, Judge. He does not work. He's, you know, from lack of a better word, I believe he doesn't have stable residency, Judge. At this time, he's just asking for the court to consider the lowest bond possible until he actually, from what he advises me, is he wants to go to trial and fight these cases.
And I believe he was already convicted by a jury in Palm Beach County. As far as this case, I don't know.
This case that we're thinking about, Mr. Lunder. And
Mr. Romero said pluralized cases, so I didn't know what he meant.
there's 2 counts.
Okay. All right, at this time, Mr. Ward, bond will be $75,000 on each count. And I'm also ordering no victim contact. And do you have the DV, no contact order? Okay, thank you. All right, and then we have, Mr. Williams.
He's approaching, Judge.
All right, Mr. Williams, good afternoon, sir. You've got some ad charges. Count 4 is tampering with witness testimony. And then you've got a probation violation or community control violation for which is a no bond hold. The court does find probable cause. State.
1 moment, Your Honor, just finding my notes for this morning. Your Honor, the state is recommending a $100,000 bond and no victim contact. So the court is aware of a little bit of the backstory here. He was being held charges of aggravated battery and domestic violence battery by strangulation against this same alleged victim. He had a total bond of $75,000 in a GPS.
This was the jail calls?
The jail calls, Your Honor, and Your Honor, and you were provided essentially transcripts of these calls where he's made, I think, veiled threats, some clear threats, Your Honor. The point is that, Your Honor, a $75,000 bond wasn't enough to get him to respect a no contact order. The risk of having those bonds revoked and held wasn't enough. So I don't see any other options but to recommend a $100,000 bond now and hope that he will obey the court's no contact order and stop having communication with his victim and not interfere in the integrity of the judicial process.
All right, defense.
Judge, he's being held no bond on count 3. He did advise me he went to court. I know the deputies rushed to bring him here. There was a sense of urgency, I believe, on the state's part to have him this afternoon. He wasn't going anywhere. He would have been able to be here tomorrow, but I mean, he's being held no bond anyway, Judge. To throw an extra $100,000 bond, it's I don't know if it's warranted, Judge, considering he already has a no bond hold, but nothing else from the defense at this time.
And I just want to note, I'm not suggesting to just throw another $100,000 here because he's alleged to have committed a new law offense violating a contact order if connected to new criminal activity.
All right. At this time, bond will be $100,000, no bond hold on 5, and no victim contact, Mr. Williams. Good luck to you, sir.
Award,
I get, yeah.
they might not have named the person, but it's his name.
State on Ward, the matter just before Mr. Williams on the information that the court had, it redacted the victim's names. She's got to make it.
I'll get that to you right now.
Okay.
All right, thank you.
I'll give it in. Thank you.
All right, Mr. Romero, who do you have left with you, sir?
Judge, I'm going to ask for a little bit of the court's indulgence. I didn't know we had this gentleman, but he was brought, so I believe we do. I tried to gather information. His name is Ivory Yearby. I believe he may be on the misdemeanor second docket.
Yeah, I've got him.
Come on up, Judge. And normally I'm a little bit better prepared, but I believe he's been in custody 5 days. When he came in on a misdemeanor and a VOP. I spoke to him, Judge. I haven't verified it, but according to him, he resolved his VOP already. It was revoked. He advised.
It's just a trespass.
And Hector, since you haven't talked to him yet, do you want me to relay the offer if he's interested in resolving, and then you can talk to him before you find out what the offer is?
Yes.
Okay. Adjudication time served. There'll be no return to Taverna Chrysler at 777. It appears he's good with that. North State Road 7 in Plantation. Yes.
And Judge, that's what he thought, it was gonna be, and he wishes to accept the fatality. The judge can hear you. Yes.
All right, Mr.
But,
Yearby,
yeah, can I ask you a question here?
Mr. Yearby, as best as you can, sir, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Please state your full name for the record.
I really Yerby.
All right, Mr. Yerby, you're charged with one count of trespassing. The state has offered you an adjudication time served, no return to, I think it's the Taverna Chrysler at 777 North State Road 7. And what city is that?
Plantation.
In Plantation. You'd also have 12 months to pay your court costs. Under those terms, you want to resolve the trespass?
Yes.
Did your attorney answer all of your questions?
Yes.
Do you need any more time to speak with your attorney?
No.
Is anyone forcing, coercing, or threatening you to resolve your case?
No.
Are you under the influence of any drugs, alcohol, or intoxicants?
No.
Ever been treated for a mental or emotional illness?
No.
Mr. Yerby, you have the right to require the state prove the charges against you, the right to defend the case by having a trial, calling witnesses, and taking an appeal. By taking this plea today, you're waiving those rights. You understand that?
Yes.
Sir, I'm not asking if you're a U.S. citizen, but I'm required to let you know that if you're not a U.S. citizen, taking a plea today will be used against you in any deportation or other immigration proceedings. You understand that?
Yes.
Similarly, if and only if in the past you've been previously convicted of a sexually motivated offense, this plea will be used against you in any involuntary civil commitment proceeding under the Jimmy Rice Act. You understand that?
Yes.
Mr. Yerby, you understand everything we've discussed here today?
Yes.
How do you wish to plea?
No contest.
Court accepts your no contest plea. I find it's given freely, knowingly, and voluntarily. I do find a factual basis for the plea. Your sentence, in accordance with the plea agreement, is an adjudication time served. No return to Taverna Chrysler at 777 North State Road 7 in Plantation. You'll also have 12 months to pay your court costs. Good luck to you, sir.
Judge, the last gentleman we have here is on your FMN docket. His name is Albert Walkins. He is on page 2 of the docket.
Yep, I've got it here. All right. State,
I'm sorry, Your Honor.
Albert Walkins.
Albert Waltons, yes, Your Honor. Yes, it's a motion for release, Your Honor, and date. State has filed information, Your Honor.
All right, so Mr. Walkins, I am denying the motion for release at this time. The state has filed their formal charges. That means you'll proceed to your division judge for further relief. Good luck to you, sir. All right, Mr. Romero, anybody else at Maine?
There's nobody else at me, Judge.
All right, what say you for Monday, 9?
9, please.
All right, 9 a.m. on Monday.
Your Honor, I just want to make sure, there was someone on the second look docket, but I guess he's not there. That's Mr. Wilson Diaz Perez.
Wilson Diaz Perez. He what? They're double checking right now. One second, Judge.
All right. All right. Well, while they're checking, then Mr. Steinberg, who do you want to go to next?
Your Honor, we have looks like we only have one at Paul Ryan.
Okay.
Pardon me, we have 2. That's the fewest, looks like. And so we have on page 2 of the FMN docket, Ashley Edmond.
Okay.
If you could come up, please.
Let's do Ashley Edmond, if you wouldn't mind just approaching.
And Your Honor, we're going to be, well, I don't want to get ahead of myself, but if the motion, if they haven't filed, we're just going to withdraw the motion anyway. And that is because I spoke with Ms. Edmond. She has a no bond hold on a violation of pretrial release. She wants to make sure she's still getting credit for time served on that. If the
Well,
state.
yeah, we haven't filed, so I guess we can that you're withdrawing the
So
motion.
withdraw the motion.
Okay, so Ms. Edmond, the Public Defender's Office is withdrawing their motion at this time, so no action will be taken by the court today. Good luck to you, Ms. Edmond.
Thank you.
Your Honor, the remaining person at Fall Run is should be Ms. Palmer.
All right, we have Ms. Palmer. And this is a second look?
Yes, Your Honor. Ms. Palmer is here in custody on a driving license suspended
Mhm.
with a $500 bond or failure to register a motor vehicle, which is already an ROR. She's asking if there's an opportunity to resolve the case.
It would be 10 days. She's already got, I guess, she was arrested on the 23rd. This, hold on, just one moment, Your Honor. Arrested on the 23rd. Well, however the time is calculated, Your Honor, but it would be 10 days, and it's because of her prior DWSs, it would be a mandatory sentence.
Your Honor, I hadn't contemplated that it would be 10 days. May I have a brief moment to speak with Ms. Palmer, please?
Sure. We'll be in recess for 5 minutes.
Your Honor, thank you for giving me the opportunity to speak with Ms. Palmer. She's first asking the court to consider granting an ROR on this nonviolent offense, and she's been in custody since the 23rd, so it looks like she's going on about 6 days here. But if the court is not inclined to do that, she would like to accept the state's offer.
Yeah, just to let Your Honor know, as far as the bond, I confirmed, and it was mentioned in her probable cause affidavit, she has an active warrant out of Dade County for failing to appear in a traffic matter. I'm showing an arrest last year out of the state of Connecticut for, I'm sorry, it was 2023, for reckless driving. She had a $10,000 bond on that.
All right, yeah, I wouldn't be inclined to ROR at this time. So if she is she's going to accept the state's offer?
She would like to do that in the alternative, yes, Your Honor.
All right, ma'am, as best as you can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, you can put your hand down. Please state your full name for the record.
Stacy Palmer.
All right, Ms. Palmer, and state, just so I'm clear, the plea is just on the operating with the suspended license.
Yeah, I would just do a withhold in court. I'm sorry. Thank you, Judge. I would just do a withhold court cost on a failure to register vehicle.
Okay, and then I see that there's also a tag unsecured and
I
then
think those are.
just citations.
Those are fractions. If Your Honor is inclined to dismiss them, the state has no objection.
All right, so that's what we'll do. We'll dismiss both those as well. All right. So in exchange for a plea, the offer from the state to resolve your case today as it relates to the operating with a suspended license, be an adjudication, 10 days in the Broward County Jail. You'll have credit for some time served. You'd also have 12 months to pay your court costs. On the failure to register the vehicle, it would be a withhold of adjudication and 12 months to pay court costs. On the 2 citations that you received, I'd just dismiss those. Under those terms, do you want to accept the plea from the state?
That would be fine.
Okay, all right. Has your attorney answered all your questions?
If I could speak with him one more time afterwards, if you don't mind.
He's going to call you right now. If you wouldn't mind just pressing that triangle so it illuminates red.
Yes, ma'am. Are you saying you don't want to start the Well, that's not going to prevent you from accepting this offer if you'd like to. The fact that you didn't know there was no particular case really has no bearing on what we're doing today. You didn't know that there was an open case in Miami.
Okay.
Okay, well, this is not a Miami case. This is a Broward case. You're in Broward County right now, charged with a driving while license suspended, and the court is offering you the opportunity to resolve the case. It's a separate case, separate from what you have in Dade County. So, there's not much for us to talk about regarding your Dade case. Dade County stuff. No, we wouldn't. You would take the offer or you decline the offer.
State, how many DWLS convictions does she have? Because I think,
I believe I've answered her questions and she's on her way back.
all
I'm
right.
counting 1, 2, 3, 4, 5, 6.
Within how many years?
Oh, it's a long period, but under this statute, it's in a lifetime.
Okay, all right. And ma'am, before we go any further, I just want to advise you that 3 driving while suspended convictions within 5 years is mandatory 10 days in jail. And then 3.
I've accepted it, sir.
I
I've
understand.
accepted.
Yeah, I understand. I still have an obligation to let you know this. And then 3 within 5 years means that your license would be suspended for 5 years. Do you still wish to proceed?
Yes, sir, I do.
All right. And your attorney's answered all your questions?
Yes, he has.
Do you need any more time to speak with your attorney?
No, sir, I did.
Is anyone forcing, or threatening you to resolve your case?
No,
Are you under the influence of any drugs, alcohol, or intoxicants?
not.
Ever been treated for a mental or emotional illness?
No, I haven't.
Ma'am, you have the right to require the state prove the charges against you by having a trial, calling witnesses, and taking an appeal. By taking a plea today, you're waiving those rights. You understand that?
Yes, I do.
Ma'am, I'm not asking if you're a U.S. citizen, but I'm required to let you know that if you're not a U.S. citizen, taking a plea today will be used against you in any deportation or other immigration proceeding. Do you understand that?
I do.
Similarly, if and only if in the past you've been previously convicted of a sexually motivated offense, this plea will be used against you in any involuntary civil commitment proceeding under the Jimmy Rice Act. Do you understand that? And Ms. Palmer, do you understand everything we've discussed here today?
Yes, I do.
All right. You could plead guilty to the charges, or you could plead no contest to them. It's totally up to you.
No contest.
The court accepts your no contest plea. I find it's knowingly, freely, and voluntarily given. I do find a factual basis for the plea. As to the operating with a suspended driver's license more than once, it'll be an adjudication, 10 days in the Broward County Jail, 12 months to pay your court costs. You'll also have credit for, I think, 4 days. Is that correct?
Correct.
You'll have,
Yes, sir.
you'll have 4 days time served. As to the failing to register a motor vehicle, it'll be a withhold of adjudication, 12 months to pay your court costs. As to the 2 citations, the unsecured obscured tag and the lack of insurance, I'll be dismissing both of those. So good luck to you, Ms. Palmer.
Thank you.
All right, thank you, ma'am. All right, Mr. Steinberg, who do we have next?
Your Honor, if you wanted to go, there seems to be 3, I think, or at Conti.
All right, let's go to
Your
Con,
Honor,
yes,
Diaz Perez is back at Maine if you want to go back
Maine.
to Maine.
all right. All right, we have Mr. Diaz Perez.
That is correct, Judge.
All right, and this is
I think it should be on the FMN docket.
Second look.
Oh, it's the second look?
I don't-
Judge, I know he advised me he's been in custody since late February. When we were trying to look up in the system, I believe he's been.
yeah, I see it here, but I don't have any information. I don't have an arrest date.
No, here's what's happening, Your Honor. And let me just get a little information here. So this is actually gonna be his 3rd look. When he was first arrested, he was arrested for possession of cocaine, theft and resisting without violence. He had a 2nd look, no action was taken. The state filed information. We did not file the possession of cocaine. We filed the misdemeanor charges. The jail reached out to pretrial to have him set for another one. If he wishes to resolve this matter, the offer from the state would be an adjudication, time served on both counts, and just pulling the probable cause affidavit. No return to Publix at 6921 West Broward Boulevard in Plantation.
All right, Mr. Romero.
One moment, Judge, let me relay that to him.
And state, what were the 2 misdemeanor charges?
Theft and resisting without violence.
That she wishes to accept the state's offer.
All right, Mr. Diaz Perez, as best as you can, sir, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. Please state your full name for the record.
My full name is Wilson Ariel Diaz Perez.
All right, sir, you're being charged with theft and then also resisting without violence. In exchange for a plea, the offer from the state to resolve those would be an adjudication, time served, no return to the public, 6921 West Broward Boulevard and Plantation, and 12 months to pay your court costs. Under those terms, you want to resolve those charges?
Yes, Your Honor.
Has your attorney answered all your questions?
Yes, he did, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
Is anyone forcing, coercing, or threatening you to resolve your case?
No contest, Your Honor.
My question was slightly different. My question was, is anyone forcing, coercing, or threatening you to resolve your case?
Oh, sorry, Your Honor. Oh, Your Honor. No, Your Honor. No.
All right. Are you under the influence of any drugs, alcohol, or intoxicants?
No, Your Honor.
Have you ever been treated for a mental or emotional illness?
No, Your Honor.
Sir, you have the right to require the state prove the charges against you and the right to defend the case by having a trial, calling witnesses, and taking an appeal. By taking a plea today, you're waiving those rights. You understand that?
Yes, Your Honor.
I'm not asking if you're a U.S. citizen, but I'm required to let you know that if you're not a U.S. citizen, taking a plea today will be used against you in any deportation or other immigration proceeding. Do you understand that?
Yes, Your Honor.
Similarly, sir, if and only if in the past you've been previously convicted of a sexually motivated offense, this plea will be used against you in any civil commitment proceeding under the Jimmy Rice Act. Do you understand that?
Yes, Your Honor.
And you understand everything we've discussed here today, sir?
Yes, Your Honor, I did.
How do you wish to plea?
No contest, Your Honor.
I accept your plea. I find it's knowingly, freely, and voluntarily given. I do find a factual basis for the plea. Your sentence, in accordance with the plea agreement, is an adjudication time served on each count, 12 months to pay your court costs, no return to the public at 6921 West Broward Boulevard, Plantation. Good luck to you, sir.
Now, I believe that is it for me, Judge.
All right, and then I will see you Monday at 9 a.m.
See you then, Judge. Take care.
All right, thank you. You as well. All right, Mr. Steinberg, who's next?
All we have left is Conti, Your Honor.
All right.
Looks like there are about 4.
All right, Conti, who do we have first?
I have Mr. Robert Murphy.
That's a motion for our order, Your Honor.
All right, so Mr. Murphy, we're here to find out if the state has filed their formal charges. State?
Your Honor. And information has been filed. Thank you.
All right, so Mr. Murphy, I am denying the motion for release today. The state has filed their formal charges, so you'll proceed to your division judge for further relief. Good luck to you, sir.
Thank you.
Thank you.
That's very, Your Honor.
All right, and this is also a motion for release?
Yes, Your Honor.
All right, state?
Sorry, Your Honor. Who's this?
Atterbury?
Atterbury charges. At this point have not been filed, so he's entitled to release.
All right, so Mr. Atterbury, I'm granting your motion for release. If nothing else is holding you, you should be released today. Please check with the public defender's office. Please check with the clerk of courts to see if there's any future court events that you need to be present for. Good luck to you, sir.
Your Honor, Mr. McLean, the second look docket, McLean.
All right, this is another motion for release.
Yes, Your Honor, he,
The second look.
yeah, he is county sentenced on a separate felony till May 5th. If he wishes to resolve this matter, the offer being adjudication time served, no return to the Winn-Dixie Liquors at 680 North Federal Highway in Fort Lauderdale.
Your Honor, I spoke with Mr. Quincy. Now, he indicated to me that he is sentenced on that VOP, but he told me that there was going to be an additional requirement, something I think that had to be filed or something before his probation is finally terminated.
Well, regardless, and Fernanda, if you can correct me if I'm wrong, or let me know, when this was originally a felony petty theft that we down filed, that felony petty theft, I believe, is the basis for the 94806 VOP that he's currently sentenced on. Is that correct, Fernanda? So he can't, pleading this out can't be used against him because it was this offense essentially was already the basis when he pled to the VOP, if that's a concern.
All right, Your Honor. I didn't realize that when I spoke to him. He told me there was still some requirement for resolving to satisfy his VOP. So
Oh, there might be a special condition of his jail sentence, like, and I'm not saying this is what it is, but like, yeah, complete the life skills program or something. I'm just saying.
Yes, sir.
Yep, there you go. I'm just saying, just so Mr. McLean understands, he can't be reviolated based on this offense, or this plea can't be used against him because effectively this offense was already used as a basis for his violation of probation.
Your Honor, I got the impression that he would like to resolve it, and that was from speaking with him, but I need to, if I may, please, just take a moment just to make sure.
Yeah,
Eric, what was the address? No return to work?
680 North Federal Highway in Fort Lauderdale. It's the Winn-Dixie Liquor. No, Fort Lauderdale. Sure.
long as you have a knife review, it's the shape frames out of that, every one. Now, it's adjudication.
The adjudication time served. You know,
No, you're not a U.S. citizen. You want to do this, you're a convicted exception, where the crimes that would be used against you in voluntary supervision proceedings, I don't want you to do. All right, so I'm gonna bring you back, and we're gonna go ahead and see, don't judge me, accept law, come on back. Your Honor, I spoke with him, thank you for allowing me a moment to do that, and he should be right back,
All right.
and he would like to accept the state's offer.
All right, Mr. McLean, as best as you can, sir, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Please state your full name for the record.
My name is Quincy Jermaine McLean.
All right, and state, what's the underlying charge?
it's a petty theft, Your Honor.
All right, sir, you're charged with petty theft. In exchange for a plea, the offer from the state to resolve your case today would be an adjudication time served, 12 months to pay your court costs, no return to the Winn-Dixie Liquors at 680 North Federal Highway in Fort Lauderdale. Under those terms, do you wish to resolve your case?
Yes, sir.
Did your attorney answer all of your questions?
Yes, sir.
Do you need any more time to speak with your attorney?
No, sir.
Is anyone forcing, coercing, or threatening you to resolve your case?
No, sir.
Are you under the influence of any drugs, alcohol, or intoxicants?
No, sir.
Ever been treated for a mental or emotional illness?
No, sir.
Sir, you have the right to require the state prove the charges against you and the right to defend the case by having a trial, calling witnesses, and taking an appeal. By taking a plea today, you're waiving those rights. You understand that?
Yes, sir.
Mr. McLean, I'm not asking if you're a U.S. citizen, but if you're not a U.S. citizen, taking a plea today will be used against you in any deportation or other immigration proceeding. Do you understand that?
Yes, sir.
Similarly, if and only if in the past you've been previously convicted of sexually motivated offense, this plea will be used against you in any involuntary civil commitment proceeding under the Jimmy Rice Act. Do you understand that?
Yes, sir.
And do you understand everything we've discussed here today?
Yes, sir.
How do you wish to plead?
No contest.
Court accepts your no contest plea. I find it's knowingly, freely, voluntarily given. I do find a factual basis for the plea. Your sentence in accordance with the plea agreement is an adjudication time served, no return to the Winn-Dixie at 680 North Federal Highway in Fort Lauderdale in 12 months to pay your court costs. Good luck to you, sir.
Thank you, sir.
Thank you. All right, Mr. Steinberg, who do we have next?
Two more, Your Honor, and this would be,
This is Mr. Lowry on the second one. Project Kevin
All right, yep,
Yes.
we've got Mr. Lowry here. This is a petty theft.
yes, Your Honor, he's got a $150 bond. He's asking, he's unable to post any sort of bond. He's asking if the court grants an ROR as he's been in custody since 24, so he's got approximately 4 days in. Or in the alternative, if there is an offer from the state to resolve it, he would be interested in that as well.
The offer for Mr. Lowry to resolve would be an adjudication time served, no return to the Walmart at 3801 Turtle Creek Drive in Coral Springs.
Your Honor, if the court is not inclined to ROR Mr. Lowry, then he'd like to accept that offer.
Yes.
What's the history state?
And just so your honor's aware, you found probable cause, and I don't mind if Yolanda, if you want to put it on disposition, it's petty theft less than $100.
Oh.
I just figured, were you asking that because it says on there, second?
No, I mean,
Oh,
it's,
okay.
you know, between RORing him and asking him to take a plea.
Okay, no, that's,
Yeah,
let me look this up. Well, I can tell you right now, as far as Broward, he had a 2024 felony battery against a victim over 65. He was sentenced to 270 days in county jail.
all right. So, sir, do you want to accept the state's offer?
Yes,
All right, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
yes.
State your full name for the record, please.
Ken Lowry.
Mr. Lowry, you're charged with petty theft. In exchange for a plea, the offer from the state to resolve your case today is an adjudication, time served, 12 months to pay your court costs, no return to the Walmart at 3801 Turtle Creek Drive in Coral Springs. Under those terms, you want to resolve your case?
Yes,
Did your attorney answer all of your questions?
yes.
Do you need any more time to speak with your attorney?
No, sir.
Is anyone forcing, coercing, or threatening you to resolve your case?
No, sir.
Are you under the influence of any drugs, alcohol, or intoxicants?
Sir.
Ever been treated for a mental or emotional illness?
No, sir.
Sir, you have the right to require the state prove the charges against you, to defend the case by having a trial, calling witnesses, and taking an appeal. By taking a plea today, you're waiving those rights. You understand that?
Yes, sir.
Sir, I'm not asking if you're a U.S. citizen, but if you're not a U.S. citizen, taking a plea today will be used against you in any deportation or other immigration proceeding. Do you understand that?
Yes, sir.
Similarly, if and only if in the past you've been previously convicted of a sexually motivated offense, this plea will be used against you in any involuntary civil commitment proceeding under the Jimmy Rice Act. Do you understand that?
Yes, sir.
Do you understand everything we've discussed here today?
Yes, sir.
How do you wish to plead?
No contest.
The court accepts your no contest plea. I find it is knowingly, freely, voluntarily given. I do find a factual basis for the plea. Your sentence in accordance with the plea agreement is an adjudication, time served, 12 months to pay your court cost. No return to the Walmart at 3801 Turtle Creek Drive in Coral Springs. Good luck to you, Mr. Lowry.
Thank
And then,
Next one, Mr. King, you're on the second look docket.
all right, Mr. King. All right, Mr. King, this is a second look.
Yes, Your Honor. Mr. King is in custody on a burglary, unoccupied structure, unarmed with a $20,000 bond. And then grand theft auto times two, $1,500 bond. At this time, he's unable to post bond. He is asking the court to grant an ROR or in the alternative, pretrial release. Now, he said that he is in between residences at this time, so he doesn't currently have a stable address. So if we're inclined to grant pretrial release, he would be requesting an open schedule. He's lived in South Florida all his life, but he has no income and he has no money in the bank to post bond. If the court finds that non-monetary release is not an option for Mr. King, he would ask the court to consider a bond reduction.
All right.
Your Honor, the state is asking that the court keep the bonds in place. He appeared before Judge Tudor for his first appearance when Your Honor was out. The reason I wasn't here, I believe the reason Judge Tudor set the bond on the burglary, particularly in that amount, is the fact that Mr. King was out on an attempted burglary conveyance when he got arrested for this new burglary.
All right. At this time, the court is going to take no action. Good luck to you, Mr. King. All right. Anyone else, Mr. Steinberg?
I believe that's everyone, Your Honor.
All right. So we'll start at 9 a.m. on Monday.
Sounds good, Your Honor. Just had one matter of request for a outside of today's session, and I cleared it with everyone.
All right. So we'll be adjourned until, well, tomorrow, but for me, Monday.